Our firm handles medical malpractice cases in the state of Alabama. They're very difficult type cases to win. In fact, they're probably the hardest case to win in all of Alabama. And why is that? Well, Alabama has what's called the Alabama Medical Liability Act. And it was a piece of law that was passed back in the late 80s that was specifically designed to protect doctors, hospitals, nursing homes, etc. And there was this big movement by the healthcare industry and the medical malpractice insurance companies to convince everyone that lawyers like us were suing doctors, hospitals out of business. It wasn't really true, but it worked, and what resulted was the Alabama Medical Liability Act. Now, what is the Alabama Medical Liability Act? Well, it's statutory. There's several rules that the plaintiff's attorneys have to meet just to get to the courthouse steps. And if you don't meet all of those statutes, your case will get dismissed likely before you even have the right to have your case heard before a jury. I don't have time to go through all of those rules today, but the most important and the one that makes it most difficult to win a malpractice case is the expert testimony requirement. In Alabama, you have to have testimony from a similarly situated expert witness. So what I mean by that is if you want to bring a claim against a neurosurgeon, you have to find another neurosurgeon who is practicing at the same time and for a year prior. And if the neurosurgeon you want to sue is board certified, you have to find a neurosurgeon that is board certified as well. You basically have to match them up. They have to be like mirror images. You have to hire that expert witness. The expert witness has to review all of the evidence, most likely wants to review all of the medical records. And that expert witness has to be able to come to the conclusion and be willing to testify under oath that the physician or healthcare provider you want to sue breached the standard of care. Now, what does that mean? Breaching the standard of care is equivalent, it's how we explain it, to making an F on your report card as a healthcare provider. They can get away with making a D-, and you have to prove that this was just completely unacceptable. There's a lot of other things that make it difficult to win. And the most practical one is that it's very difficult, at least in Alabama, to find an expert witness who is willing to testify against another healthcare provider. You know, they don't want to point the finger at each other, and I get that. But we have to go places far and wide, you know, the West Coast, the Northeast, to find healthcare providers who are willing to testify that another healthcare provider breached the standard of care. Another thing that makes it difficult is that we're not able to discover other acts and omissions. You know, has a doctor screwed up in the past in a very similar way as he screwed up in treating you? Well, you would think that would be relevant, and it is, but we cannot even discover that information during the litigation process, and we certainly can't offer it as evidence at trial. There's a lot of other things out there about the Alabama Medical Liability Act that make it very difficult for patients who have been hurt, or for the family of patients who died as a result of what they believe is medical negligence. We handle these type cases, but we're very selective about which ones we choose to take because we have to spend a lot of our time, a lot of our money hiring expert witnesses just to be able to get to trial. They usually don't settle until you're able to get over all of those statutory hurdles. And even if you are, a lot of times they still don't make an offer and you have to go to trial. So they're tough cases to win. We do review them. We do our homework on the front end by thoroughly reviewing the medical records, consulting with potential expert witnesses, and only take the case really if we think we have a substantial chance of winning the case.